The Supreme Court pronounced its verdict on Article 370 abrogation today. Chief Justice of India, D.Y. Chandrachud, said that Article 370 was a temporary provision due to war conditions in the region. He ordered the restoration of statehood in Jammu and Kashmir at the earliest, directing the Election Commission of India to ensure elections by 30th of September 2024. The Supreme Court bench had 3 separate judgments on the issue based on 3 opinions. On the validity of Article 370, the Chief Justice of India said the Constituent Assembly of Jammu and Kashmir was never intended to be a permanent body, and when it ceased to exist, the special condition for which Article 370 was introduced ceased to exist as well.
We have held that Article 370 is a temporary provision on a reading of the historical context in which it was included. Article 370 was introduced to serve 2 purposes. First, the transitional purpose to provide for an interim arrangement until the Constituent Assembly of the state was formed and could take a decision on the legislative competence of the Union on matters other than the ones stipulated in the instrument of accession and ratify the Constitution. And second, a temporary purpose, an interim arrangement in view of the special circumstances because of the war conditions in the state. The state of Jammu and Kashmir does not retain any element of sovereignty after the execution of the instrument of accession and the issuance of the proclamation dated 25 November 1949, by which the Constitution of India was adopted. The state of Jammu and Kashmir does not have internal sovereignty, which is distinguishable from the powers and privileges enjoyed by other states in the country. Article 370 was a feature of asymmetric federalism and not sovereignty. This court is alive to the security concerns in the territory. Direct elections to the legislative assemblies, which is one of the paramount features of representative democracy in India, cannot be put on hold until statehood is restored. We direct that steps shall be taken by the Election Commission of India to conduct elections to the Legislative Assembly of Jammu and Kashmir, constituted under Section 14 of the Reorganization Act by 30 September 2024. Restoration of statehood shall take place at the earliest and as soon as possible. We have held that a textual reading of Article 370 also indicates that it is a temporary provision. For this purpose, we have referred to the placement of the provision in Part 21 of the Constitution, which deals with temporary and transitional provisions, the marginal note to the provision, which states temporary provisions in respect to the state of Jammu and Kashmir, and a reading of Articles 370 and 1, by which the state became an integral part of India upon the adoption of the Constitution.
Political reactions coming in. PDP's Mehbooba Mufti is reacting. Let's take a listen.
1947 में आज आपने उस हाथ को जख्मी कर दिया, इसलिए हिम्मत मत हारो मेरे भाइयों, मेरी बहनों, मेरे बच्चों। ये वक्त भी नहीं रहेगा। मैं अपने देशवासियों से कहना चाहती हूं, आप में से कई लोग इस वक्त जश्न मनाते होंगे। जम्मू कश्मीर के लोगों के आंसू देखते हुए, उनकी तकलीफ देखते हुए, जो जम्मू कश्मीर को आज फिर से जेल में कन्वर्ट किया गया, दुकानदारों को बोला गया, उनको धमकी दी गई कि सुबह 10 बजे दुकानें खोल दो, हमें घरों में नजर बंद किया गया, वर्कर्स को थानों में बंद किया गया। तो इससे डरने की जरूरत नहीं है, इससे घबराने की जरूरत नहीं है। मैं अपने लोगों से कहना चाहती हूं, मैं अपने मुल्क के लोगों से कहना चाहती हूं कि जो 2019 5 अगस्त को हमारे मुल्क के संविधान के साथ हुआ, जिसकी वजह से हमारा अपना छोटा सा संविधान छीना गया, हमारा झंडा जो तिरंगे के साथ छोटा सा झंडा था उसको छीना गया, ये बात यहां रुकने वाली नहीं है। जो शुरुआत जम्मू कश्मीर से हुई है वो पूरे मुल्क में फैलेगी। जो हमारा संविधान है, बड़ा संविधान है, जो तिरंगा है, जिसके नीचे आजादी की लड़ाई लड़ी गई और जीती गई, इसको भी आपसे छीनने में जरा देर नहीं लगाएंगे ये लोग। मगर उस वक्त हम आपकी तरह जश्न नहीं मनाएंगे, बल्कि दुआ करेंगे कि आप भी हिम्मत और हौसले के साथ इनका मुकाबला करो। मैं फिर से अपने जम्मू कश्मीर लद्दाख के लोगों को कहना चाहती हूं, मेरे भाइयों, मेरे बच्चों, मेरी बहनों, हिम्मत नहीं हारनी है। किसी भी सूरत में नहीं। कोई फैसला अटल नहीं होता, चाहे वो सुप्रीम कोर्ट का ही क्यों ना हो। हमारे लिए कोई फैसला अटल नहीं। ये एक सियासी लड़ाई है जो पिछले कई दहाइयों से चल रही है। हमारे लोगों ने बहुत कुर्बानियां दी हैं इज्जत नफ्स हासिल करने के लिए। हम इसको अधूरा नहीं छोड़ेंगे, मगर बशर्ते कि हम इकट्ठे हो जाएं, एकजुट हो जाएं और ये लड़ाई, ये जद्दोजहद इकट्ठे लड़ें। मैं आप सबकी बहुत शुक्रगुजार हूं, आपने मेरी बात सुनी और उम्मीद करती हूं कि आप दिल में नाउमीदी, शिकस्त को जगह नहीं देंगे, बल्कि उम्मीद के साथ, एक नई उम्मीद के साथ, एक नई जद्दोजहद के साथ आगे चलेंगे। बहुत बहुत शुक्रिया आपका।
Anisha, in fact, continues to be with us as far as the big verdict by the Supreme Court of India is concerned. Anisha, we were talking about a lot of things that have been said by the court today, by the Chief Justice also, why pronouncing this verdict. Talk to us about the fact that the court today essentially has also underscored on the powers of the President, and this in a way sets a precedent as well, isn't it?
Well, yes, the Supreme Court, now we need to be a little nuanced when we discuss what the court has said about the power of the president. The power of the president specifically under Article 370 is what the court has discussed, where it has said that yes, the power of the president to abrogate Article 370 was in fact in existence because it is within the provisions of the Constitution itself. Now, what the court has said that the recommendation of the legislature or the concurrence of the legislature was not necessary because their view is only recommendatory, and that is something that they have said, that the legislature of the state, as far as what the petitioners had said, that recommendation of the legislature is necessary, that is only a recommendatory point. What the court has said, that the continuous exercise of power, and I'm reading this from the judgment here, the continuous exercise of power under Article 371 by the President indicates that the gradual process of constitutional integration was ongoing, and the declaration issued by the President under Article 370 Clause 3 to abrogate the provision is a culmination of the process of national integration, and therefore it is a valid exercise of power. Remember, this is something that is specific to the Union Territory of Jammu and Kashmir, the status of Jammu and Kashmir per se, because Article 370 in itself gave this power to the President of India. They also, the court also said that the CO or the orders passed by the President of India in exercise of his powers were valid because it was within his power under Article 373. So this is a very clear comment from the Supreme Court when it comes to the power of the President to take away Article 370, the special provision that was made. In fact, the court has noted that similar special provisions had been made for other states as well under various other provisions of 370 in this country. Back to you.
Anisha, thanking you for the moment. We'll of course keep coming back to you for more on that big story that we're tracking very, very closely from the Supreme Court of India, that decision that has a judgment that has many, in fact, political ramifications.